Ncaa Guide.
Every year, a significant number of foreign-trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the Ncaas and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The Ncaa exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the Ncaa. This is where we come in.
I have written and passed the Canadian Administrative Law exams.
I have taken and passed the Canadian Professional Responsibility examination.
I have written and passed the Canadian Criminal Law examinations.
I have written and passed the Canadian Constitutional Law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the Ncaa examinations present and will help candidates overcome these difficulties and obstacles in understanding the course materials and the exam format.
We do this through intensive classes, revisions, spot tests, and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a good track record and excellent results from our past and present candidates. If you're writing the Ncaa exams and you want to pass them all at your first attempt, join our classes today.
Okay, so the very first chapter we have in your syllabus is the sources of Canadian criminal law. Basically the importance of this chapter is for you to know that your criminal law, the source of your criminal law is usually the criminal code that you have. However, sometimes you find that because of the need to curb a particular kind of crime, you would have other sources or other source of criminal law as well. So majorly, for the purposes of Ncaa, you're going to be dealing with the Canadian criminal law, Canadian criminal code, or when we get to speak to the offense of regulatory offense, you may be dealing with other kind of, laws as well. But majorly, primarily, you will be dealing with the Canadian criminal law, right? And the whole essence of all of this is that before you can say that, an offense has been committed, or before you can punish somebody for a crime, you must be able to say that a particular statute or legislation actually prohibited that crime. And the prohibition or the enactment of the law must always precede the act. So your criminal code is such that it is written, it's definitely pre-existed, whatever act or conduct that an accused person had committed. So you have to be able to see it in clear terms. It must not be so vague. It must not be vague. It must be, interpreted in such a way that it aligns with the offense that had been committed, right? So the whole essence why you would have majorly your Canadian criminal law or any other statute that had been, enacted by the Parliament as a source of criminal law is because based on the doctrine or the presumption of innocence, an accused person cannot be convicted unless he was, charged under a valid criminal law. Does this make sense to you? So you would have other statutes that would, prohibit special, act or conduct. Like, for example, you have the Controlled Drugs and Substances Act. This is a particular legislation that was, enacted to curb a particular offense. But the major offenses you have in Canada are actually contained in the Canadian Criminal Code. If you look through your syllabus here, you will find that except with the contempt of court, I believe you understand what contempt of court is, you cannot actually have common law as a source of Canadian criminal law. Does this make sense to you? It is almost impossible to have common law as a source of Canadian criminal law. Why? Because common law is unwritten, and when you have an unwritten law, an accused person is not aware or is uncertain as to the particular act that he needs to be aware of in such a way that you cannot have him or you cannot charge him for an offense that is not written. So the whole essence of having the law written is such that you are aware that there is an act or there is a law that is prohibiting a certain conduct such that you are conscious of it not to commit that offense. So as you don't get penalized for that, right? But because your common law common law is unwritten, right? So you wouldn't have common law as a source of Canadian criminal law. But of course, when it comes to contempt of court, then common law can be a source of such offense. Does this make sense to you? So as much as we understand this aspect, another point we should also note is that no matter how abhorring or how appalling a particular conduct is, or no matter how immoral a particular conduct is, it does not become an offense unless and until it is written, right? So you may have instances where society just sort of feel like this particular conduct is so repulsive that the parliament should just make it an offense, right? But the fact that the society has such reaction to such acts does not automatically make that conduct an offense unless and until the parliament actually enacts that law. Whatever observations or negative reactions you have to a particular conduct does not actually make it an offense, right? But as now that we understand this basic source of Canadian criminal law, which is essentially your criminal code, and we've said, for example, that common law cannot be a source of Canadian criminal law, but common law can be a source of defense. Common law can be a source of Canadian, defenses. Does this make sense to you? So you have instances where you have defenses like entrapment. I think when we actually get to speak to that topic, if we're able to get there, we'll touch on it today. Defenses like entrapment, officially induced error, those are examples of common law defenses. And of course, when you are entitled to raise that, you can actually raise it in the court of law. So another thing I would like to point out to us is that in interpreting criminal law offenses, common law has been a good source to that, right? The issue with this is you need to review, for example, the case of Ncaa Exams. That's one of the cases in your syllabus. You will need to see how the common law was used to interpret the issue of consent when we talk about assault, right? Under assault, maybe when we get there, we can also zoom in on that. But under the offense of assault, one of the essential elements of that offense is that the prosecutor must prove that the accused person did not get the consent of the victim, right? So if you do not have the consent of the victim to commit a crime, it becomes an element of that offense for assault, right? So, but in this case of Ncaa Exams was a case of a guy where the court had interpreted that excessive application of force, even with consent of the accused person, would not be acceptable, such that when you have a situation where you are engaged in a mutual fight, a fight where both of you consented to, and you inflict an injury that is excessive on the victim, and you go to court to say, well, the victim consented to the application of force, the moment you have a grave injury involved, the court would use the common law to interpret that such an excessive application of force would not be acceptable, regardless of the fact that you got the consent of the victim. Does this make sense to you? This is just common law that had been used to interpret, this beautiful principle of law, right? So for the purpose of your Ncaa exams, I always just say to my client that once you get a question and it's saying to you, there is no section where the accused person can be charged in the criminal code, there is no section where under any other statute where the accused person can be charged, and they're saying to you that the accused person had been said to commit a particular offense, then you would know that under your chapter 1 of the syllabus, you've been told and you've been taught that for any offense that had been charged, you must be able to link it to an existing criminal law, either the criminal code or any other legislation. Otherwise, an accused person cannot be charged for a law or for a crime that is not in existence. Does this make sense? So this will be your takeaway for chapter 1. For most of the topics in the syllabus for Canadian criminal law is mostly to give you that underlying understanding, right? Like, you're not going to have a complete question in your exam, for example, that says to use speak to the sources of Canadian criminal law. No. But what you're going to have is a situation where you're supposed to identify whether a particular criminal law, whether an accused person can be charged under an unexisting criminal law, for example. Does this make sense to you? This is not constitutional law where you're looking at validity or applicability of a particular law. But for criminal law, what you're looking at is there any act that prohibited this conduct? If there is, then the accused person can be charged. Does this make sense? I cannot see Amaka on my screen. I can only see Benazi on my screen. So it looks to me like I'm speaking to her only, but I know our video is turned on. I don't know why my screen is just, but can you just, in a minute or two or less, 1 minute, tell me what you understand with the sources of Canadian criminal law? Benazi, do you want to take that?
Yes. So so the offense must be set out in the law itself. If it's not set out in the law, it cannot be an offense.
Yeah.
And but defense, some of the examples that you've given can be such as entrapment and officially induced error are examples of common law defenses.
Good. Yes. Thank you, Benazi. It shows you're listening to me. Amaka, do you want to say something to that before we move to the next chapter?
I think she has covered it already.
Okay, nothing to add for me?
There is, even if a common law is not exactly a source of criminal law except for contempt of court,
yeah.
It also serves as it also provides defenses to crimes.
Good.
And it's also instrumental in interpreting criminal offenses.
Good. Thank you. That sounds really good. I've not heard from Daniel yet, but we are just going to proceed. I love the way Amaka and Benazi are following me on the call. So let's go to chapter 2. So chapter 2 of the syllabus is the power to create criminal offenses and the rules of criminal procedure, right? What you should know basically here is that under the Constitution, there is division of powers between the Parliament and the provincial government, right? So for criminal law, you can have the Parliament, that is the federal government, and the provincial government having the power to enact regulatory offenses. I'm going to repeat that. The federal government, the Parliament, and the provincial government both have the powers to enact regulatory offenses. But only the federal government have the power to enact criminal law offenses. And to this, you need to consult your section 91, sub 27 of the Constitutional Act of 1867, and section 92, sub 14 of the Constitutional Act of 1987 as well. So essentially, the Canadian Criminal Code has been enacted by the federal government, right? So any criminal law offense, and I see the way Amaka's eyeballs are just rolling there and there. We're going to explain. I know what you're thinking in your head right now, but so just to throw it that in Canada, you have two types of offenses. You have your criminal law offenses, and then you have your regulatory offenses. Your regulatory offenses speak to licenses and look into the welfare of the society, essentially. While your criminal law looks to punishing you for certain conduct, right? So, but what I'm speaking to you right here now is on the division of power. Right now, as it is, the federal government has the power to enact criminal law offenses as well as regulatory law offenses, while the provincial government only have the power to enact regulatory offenses. So, and to that, you look to your section 91 and 92 of the Constitution Act of 1987. So when you zoom in on the Canadian criminal law offense, what are the what are the features of the Canadian criminal law? What distinguishes it from the regulatory law offenses, right? So to this, you need to read the case of R against Mamo Levine. It's one of the cases in your syllabus as well. When you look through R and Mamo Levine, it says to you that for a law to be classified as a criminal law offense, it must possess 3 prerequisites. You must have 3 things applicable before you can say a particular law is a Canadian criminal law offense. 1, it must have a penalty. So when you open any section in your Canadian criminal code right now, you would see that there is always a penalty or a punishment for any offense that had been prohibited. So there is always a penalty involved, right? For another thing you look out for is public purpose. There must be a particular purpose that the Parliament intends to achieve for prohibiting that particular crime. So penalty, public purpose, prohibition, in the sense that the act must actually say this act is illegal. Anybody who contravenes XYZ or anybody who does XYZ commits XYZ offense. So there must be a prohibition, there must be public purpose, and there must be penalty. I always just sum this up and call it the 3 Ps for my candidates, right? So once you note that, you know, of course, you are dealing with a Canadian criminal law. But when you do not have all of these, where the issue or the law you have, the whole essence is to regulate certain conduct in the society, like your traffic offense, your water resources offense, or something like that, or environmental law offenses. Those now fall within the regulatory, spectrum of the Canadian law. Does this make sense to you? So right now, what you need to know is that the power to create criminal law offense essentially lies with what? Parliament. That's the federal government, right? Does this make sense? So then we need to now look at the Canadian Charter of Rights and Freedom. I'm using your syllabus just the way it appears in it. The Canadian Charter of Rights and Freedom is not really a source of the Canadian criminal law, but of course we know the importance of the Charter, right? Charter is another document that you need to, be familiar with when it comes to your exams. For example, you would need it very much when we come to police powers, but that's in the later part of your syllabus. I will see if we can get there, but I actually doubt if we can get police powers in this introductory class. Anyways, your Canadian Charter of Rights and Freedom is a very important document that you would need to, excel in that part of the syllabus, right? So what does it do? It just serves like some sort of watchdog on the activities of the government. It's a way to sort of ensure that whatever law or the law that had been enacted is compliant with the Charter in such a way that it doesn't breach or tramples on the rights of the Canadians. So basically you have your Section 52 of the Constitution Act. The Section 52 is the provision that says that, sorry, I'm having distraction pop up on my screen. So your Section 52 essentially is the section that helps to, review the enactment or any provision or any law, by the Parliament, and such that that law must be compliant with Charter, otherwise it can be subjected to review under Section 52. And basically, when it is held that the particular law is not Charter compliant, Section 52 allows you to strike the law down or sever the law or read into it or read down. Those are the remedies for, review of any law under the Constitution. So you have a couple of them, but that doesn't fall within the spectrum of the Canadian criminal law. You find that more in the constitutional law. But what we should know is that every criminal law that you have that prohibits certain offenses must be enacted in such a way that it's compliant with the Charter. Otherwise, Section 52 can be used to review such laws, right? And you would have that occurring in a couple of cases you have in the syllabus. For example, in the case of Canada and Bedford, very popular case, the case where this case is referred to as prostitution reference as well. It's a case where 3 prostitutes actually challenged the Canadian law on prostitution. A couple of sections under the criminal code were challenged. Section 210, 212, and 213 of the Canadian criminal code were challenged by these 3 prostitute. Basically, they say that the section was drafted in a way that prevented them from, keeping a boarding house or relying on the avails of their prostitution, and then communicating for the purposes of, engaging in their prostitution work. They went to court to say, yeah, the way and manner the law was drafted was, infringed on their right to practice their profession as a prostitute. And the law, the court looked at it and actually agreed with them to say that the law as, enacted contravened Section 7 and Section, 2 of the Charter, of the Canadian Charter. Your Section 7 is your right to life, liberty, and security of the persons under the Charter, while your Section 2 is on freedom of expression and all of that, right? So these three prostitutes actually went to court, challenged these sections of the criminal code, and the court agreed, saying the way, because the law was drafted, was actually an infringement on their rights. Does this make sense to you? So the Charter is not really a source of the Canadian law, but it has been used, or it's been used to, interpret the sections of the Canadian Criminal Code, right? So another case that you have, which I find very interesting, is Aaron Oakes. And Aaron Oakes is the case of a guy who was charged for being in possession of drugs for trafficking, right? And one of the things we should understand when we look through Canadian criminal law is the law on presumptions. It's very important because it speaks to the right of the accused persons as well. So for example, there is a presumption of innocence, right? What does that mean? It meant that everybody who has been charged, or anybody that has been charged with any offense, is presumed to be innocent. And what that means is that it places the burden of proof on the prosecutor to show beyond reasonable doubt that that accused person actually committed the offense, right? There's also the presumption of sanity, that everybody is presumed to be sane. Then if you go to court to say I'm insane, then the burden is on you to show that you're actually insane, right? The essence of presumption is it helps you to identify who has the burden or who has the duty to establish or show a particular offense in court. So as it is, the burden of proof, as we have it, is usually on the Crown to prove that the accused person has committed the offense beyond reasonable doubt, right? What happens when the Crown discharges this burden? Then the burden shifts to the accused, right? To show that there was probably a defense or a reason why he actually committed the offense, or to actually say that he didn't commit the offense. The burden shifts to him. In the case of Aaron Oakes, is the case of the guy that was, charged for being in possession of drugs, and as it was stated that it was assumed, or it was presumed, that he was in the possession of drugs for the purpose of trafficking. The way it sounded, it looks to you that the Crown had shifted the burden of proof to the accused person to show that he was in possession of the drugs, but he was not in possession for trafficking. Does it make sense? So you've been charged for being in possession of drugs. Yes, being in possession of drugs is a crime. But why would you presume, or why would the law say that I am presumed to be in possession for the purpose of trafficking? If you charge me for being in possession of drugs for trafficking, the burden should be on you to prove that I was in possession of drugs for trafficking, not the other way around, making me prove that I was not in possession of drugs for trafficking. The court looked at it and said, although as it was, he was charged under the Drugs and Substances Act, right? The way and manner that section was drafted in that enactment or in that law actually imposed that burden on the accused person. Now, Section 52 was used to review that legislation, to say any legislation that puts the burden of proof on the defendant as opposed to on the prosecutor is an infringement on the rights of the accused person. Does this make sense? So the court essentially just reverted and said, no, the burden of proof should always and remain with the Crown, not with the accused person, right? Another case you have in your syllabus is Aaron Labai. I'm tempted to always go into cases, but I know it takes my time. But with cases, it just, drives home the point clearer. Like I always just love cases. Aaron Labai is another good case where the court had to define what public purpose meant. The guy was charged with keeping a boarding house. Keeping a boarding house is an offense, you know, because of course you have a house where everybody come in and engage in some immoral conduct. But in the case of this Aaron Labai, the guy ran a boarding house, right? But he had another part or some parts of the house where it's enclosed, where nobody would actually have access to that place unless you're a member of the club, or unless you sign, of course, just be a member of the club, right? So the court was thrown into the need to define what public purpose meant, right? Or public place, rather, I beg your pardon, public place. Because anybody who keeps a boarding house where anybody can come in and engage in immoral conduct is actually an offense, right? But what is a public place? If I have an apartment that is locked, where nobody can actually come in unless you sign to be a member, where of course I would have seen that you're an adult and you want to engage in this conduct freely, and the court actually defined that place a public place. You know, trial court went to say it was a public place. On appeal, the court actually said no, that house would not qualify as a public place, and it would, the charge against the accused should, the guilty, verdict should be turned. So it was section 52 that was also used to interpret this particular provision, right? So what I'm telling you, or the giveaway for this part, is that the Canadian Charter of Rights and Freedom is like a gatekeeper or a watchdog watching the activities of the government to make sure that whatever law or enactments they have or they enact essentially should be in compliance with Charter of protecting the Canadian rights and freedom, right? So with this, I would want to hear what you understand with what I've explained before I move to the next chapter. Banazi, Amaka, who is going to take this one? Just a line or two to say, yeah, this is what you've said so far.
Well, yeah, so basically criminal law is based on the presumption of innocence, and the prosecution had to prove the guilt of the accused beyond reasonable doubt.
Yeah.
And once that's done, then the burden shifts to the accused, where then he can rely on the defenses, etc.
Good.
The Canadian Charter serves as a watchdog on the activities of the government, so that they do not step over the rights of the individuals, etc. And then the other two major cases that you've mentioned.
Good. Yeah, thank you, Benazi. That sounds really good. Amaka, your turn. And don't say Benazi said everything, okay?
So add to what you said, we should always bear in mind there are regulatory offenses and then there are criminal offenses. Good. The federal government takes care of both regulatory and criminal offenses, while the provincial government just take care of regulatory offenses. Good. And what makes a criminal offense a crime is that there's a penalty, it is prohibited, and it's for public purpose. Like there's a public purpose attached to it. I think that's
good. Sounds really good. Then the charter, of course, is the one that, just sort of watch over the activities. That's what Benazi summarized. I love that. So the next chapter is procedural classification of offenses. The procedural classification of offenses is important because it has many considerations. It determines several steps you take in the course of your criminal trial, right? Mm-hmm. So essentially, you have your classification of offenses, is the summary offenses, which is 1, and then indictable offenses, which is 2. And then you have the so-called hybrid offenses. The hybrid offense is not another type of offense, right? But the hybrid offense sort of gives the prosecutor the discretion or the opportunity to choose how he or she would love to charge the offense. Does this make sense? So you have indictable offense, you have summary offense, and then you have the hybrid that gives the Crown discretion to choose how he wants to file the charge. So it's not another type of offense, but it's just there for you to know. Why do we need to classify offenses? Very important question. You classify offenses for penalties purpose or for procedural purpose. What do we mean by penalty? For example, your summary offenses, the maximum punishment you can have for your summary offenses is 2 years imprisonment, right? Why would you have to decide whether you want to file a summary offense or file an indictment? to state this very clearly to you, in practice, when you're deciding whether to file a summary of offenses, you will be filing a document called an information. For summary offense, I'm going to take that again. For summary offenses, when you need to decide what document to file, you will be filing a document called an information. If you decide to file an indictable offense, you will be filing a document called an indictment. Does this make sense? So now it's very important that we understand the reason why we classify offenses in Canada. And I'll have to say this as a matter of caution that it's been argued, or it's been, even your Steve Pullan had said right now that the classification of offenses in Canada right now, it's so irrationally complex. And it almost is no longer serving any purpose. But it doesn't mean that we still should not understand the purpose of classifying offenses in Canada. I'm going to go back again, just so we get it clear. So you classify offenses for two reasons, for penalty and for the procedure. What do we mean for penalty, right? The moment you file a summary, the moment you file an information, right, you are essentially saying to the court that the maximum punishment that the accused person can be given is 3 years. So it speaks to how you want or how you perceive the offense to be penalized. The prosecutor has a lot of power, right? So the prosecutor can decide, okay, I'm going to file a summary offense by filing an information, and with that, the maximum punishment would be 2 years imprisonment. For the procedure, what do we mean by the procedure? In Canada, you have trials with jury or trials without jury. So you have a judge sitting alone or you have a judge sitting with a jury, right? When you file a summary offense, meaning you file an information, you are essentially saying that you do not want a jury trial because jury trial is not applicable for summary offenses.
Okay.
The moment you file an indictable offense, meaning you file an indictment, there is an opportunity for you to have a jury in that trial. So you may have a jury procedure. One or two important sections I'm going to leave you with here for this part is Section 553 of the Criminal Code and Section 469 of the Criminal Code. Section 553 is essentially your not so serious offenses, right? Where you have the theft, obtaining by false pretenses, and breach of cognizances, right? Those are considered to be not so serious and are often classified or charged as summary offenses, right? Then you have your Section 469 offenses, which are the grievous offenses where you have treason, mutiny, and all of that. Those are considered serious offenses, and you would need to, mostly file an indictment for that. But outside these offenses listed in 553 and the one listed in 469, then the accused person would have a right to choose how he or she wants to be tried. So for Section 553 offenses, no matter what you do, you cannot have a jury trial for those offenses. I'm repeating it because I saw the way Amaka's eyes went this way. You cannot have a jury trial for those kind of offenses. Okay. For offenses under Section 469, you would have a jury trial for those offenses because, of course, why? They are serious offenses, and you want to be careful to ensure that the accused person is actually guilty before you sentence them to jail, right? So the court or the jurisprudence pay more attention to the procedure adopted in such offenses, right? So, but for Section 469 offenses, the accused person can also say, I don't want a jury trial. When you say you don't want a jury trial in that situation, then you would need the consent of the Attorney General to waive that for you. Because, of course, it's a serious offense and you have the right, to be tried, fairly, in a fair trial, compliant with the principles of fundamental justice, right? But outside 469 and 553 offenses, the accused person can choose the mode of trial. You could say, you know what? I want to be tried by a judge alone. I want to be tried by jury alone. Does this make sense? Remember the caveat I gave earlier. When you go in and you study it for this, for your exams, have in mind that right now, even the jurists are saying the rationale for distinguishing or separating offenses in Canada as summary and indictable has become so convoluted, and they don't see that it even serves any purpose anymore. I'm trying to make it as clear as possible, but what it means is before now, you would classify offenses based on how grievous the offense is. So you say, okay, the offense is less grievous, okay, you go summary. The offense is very grievous, to go by an indictment. But right now, you have some offenses that are not considered to be so, less grievous, but you still have them falling within the hybrid offenses, where the prosecutor can choose how he wants to charge. Does this make sense to you? So because of these hybrid, offenses, and because you have some of these offenses now summed under these hybrid offenses, the whole essence of distinguishing these offenses in Canada now is the essence is almost unfounded, right? Well, for NCA purposes, you should still understand that you have two types of offenses. You have your summary offenses, you have your indictable offenses, and you have the one that the prosecutor can choose or has the discretion to choose how he or she wants to file the charge. What are the reasons why you identify the type of offenses or the type of offense that you're dealing with, the penalty involved, and then the procedure. Under penalty as well, you need to also consider the jurisdiction of the court. For example, summary offenses will be tried mostly in the provincial courts of any province, while you have your indictable offenses, some of which may be tried in the provincial court, while some of which may be tried in the superior courts as well. So for jurisdiction purpose, you also need to know what you're dealing with. So as a prosecutor or as a defense lawyer or as a student, when you've been asked to review a particular section, ask yourself, what kind of offense is this? Is it a summary offense? Is it an indictable offense, right? The moment to find out the answer to that question, then you need to quickly, have in mind the implication of choosing or identifying that summary offense or the indictable offense, because immediately, if it's a summary offense, you're dealing with provincial court, you are dealing with, when it comes to penalty, punishment cannot be more than 2 years. Again, for example, for summary offenses, you can only, no jury, yeah, I hear you, no jury for that as well. And then you can only serve your term of imprisonment in the provincial jail. Okay. I think essentially those 4 reasons, that this is why you're choosing a summary offense, right? But for indictable offense, then you apply it the other way around as well. You may have a jury, you may be dealing with a superior court, You may, of course, the accused person will be serving the term of jail in a federal penitentiary. And then what other reason would you have an indictment? Yeah, essentially those 3, right? So it's very important you know the kind of offense you're dealing with, such that you're able to tell the effect or the implication of such in your case. So I don't know if I'm missing out anything here, but what I always leave my students with is this. Once you have a situation or a question in your exam that says to you, what are the options? So basically, NCA exams will not come theoretically. You would have to deduce some facts from the fact scenario that you've been given. But the way I've seen that this topic is tested is when you deal with the questions on sentencing. When you deal with questions on sentencing, you need to identify the type of offense you're dealing with, because for sentencing, of course, your penalty usually will not be more than 2 years imprisonment. And you're basically taking away the discretion from the court or from the judge to decide whether they want to go higher. So for prosecutor, what are the factors that you would need to consider to decide, okay, for the hybrid offenses now, the one that you have the discretion to choose, what are the factors that the prosecutor will consider to decide, okay, I want to file this offense summary? 1, maybe the offense is not so serious. 2, maybe the accused is a first-time offender. 3, maybe the accused person is remorseful, or, so there are a couple of things the prosecutor would consider to say, okay, I will decide to file a summary, case or summary, process. But for indictment, the prosecutor can as well say, oh, well, you've committed this offense before, this particular offense that, let's say, for example, the offense of child pornography is a very grievous offense that the society, have these very negative, feelings on. So if you have an accused that committed a child pornography, right, and is a first-time offender, for example, what factors would the prosecutor decide? How would the prosecutor decide that? So you have on one hand an accused person who is a first-time offender, but you're dealing with a very serious offense as well. As a prosecutor, I think I'm going to file an indictment. And I think for this kind of offense, this example I gave, it's actually not going to be a situation where the prosecutor can choose. It's definitely going to be an indictment, right? So, but this is just to say to you the kind of, factors or considerations that the prosecutor would have in mind to decide how he or she, want to proceed. So with that, I think I've summarized the procedural classification of offenses. As we've been doing, I want you to say it back to me just in a word or two what you understand. Right? This time,
I just have a question in respect of that.
Okay.
Can it be that the prosecution files an offense as a summary offense, and then during the course of the proceedings, they realize that, oh, they discovered more and more evidence, and they realize this is a far bigger crime than they had initially anticipated, and would then the judge at that point transfer it to be an indictable offense and to the relevant courts or jury and all of that?
Your question is packed up, and you sound like a criminal lawyer. Like, do you want to practice criminal law? Because this question is really a practical question. So, for example, before you file a charge, the prosecutor has the obligation to sit, and review the evidence they have, such that you don't file a charge unless and until you're ready to file a charge, to know this is the reason why you're filing this charge, and the evidence you have can support the offense that you've charged. However, in practice, you could actually find a situation where, as you proceed or you progress in the criminal proceeding, you find more and more evidence that's so revealing that you say, oh, you know what, this is more grievous than I thought. Yes, there's always the opportunity to amend during trial, but it depends on the stage of the trial. Say, for instance, very important here in Canadian criminal law jurisprudence is the right of the accused person. Remember, at the point of filing the charge, the accused is presumed innocent, right? So the court would be fair all through the process of adjudication. So say you file a summary, an information, and the accused has pleaded to the charge, or witnesses had been called, or let's say the prosecutor was close to closing its case. When you bring an application to amend your summary, your information, now you want to turn it into an indictment, this power essentially lies with the judge. The judge would have the discretion to decide if at that point it is okay, considering the right of the accused, to still change the information into an indictment. It is not closed. It is possible that can be done, but the court will need to review the evidence that had been adduced, consider the stage of the trial, and consider whether the change will not prejudice the interest of the accused person, right? Once the court weighs all of these factors, the court can decide, okay, you can file, you can change this into an indictment, or we just need to proceed that way. So essentially, this is the job of the judge to decide if he or she is going to allow the Crown to change the summary offense into an indictment. But as a very tidy prosecutor, you would avoid a situation like that. Before you file your charge, you make sure that you want to decide it's summary, then it's a summary. You want to decide it's an indictment, then it's an indictment. You leave little room for a situation where you need to come to court with an application to say, my lord or your honor, I need to change this information into an indictment, right? So, but it's possible. Like all through the stage of the trial, the only thing the court wants to know is how would this affect the right of the accused person? How would it impact the whole exercise that the court had, expended their time on, right? So I think I don't know if I answered your question, but that was a very practical question I've had to encounter in my course of prosecutorial duties as well. So yeah.
Okay, thanks.
Amaka, now it's your turn to tell us, summarize the topic for us. procedural classification of offense. Just a word or two.
Okay. The first thing to bear in mind is that there are different types of offenses.
Yeah.
There's a summary offense, there's the indictable offense, and then the hybrid offense.
Mm-hmm.
And the essence
I don't like the way you included that hybrid in your list of offenses.
Okay. Okay.
Because you make it sound like it's the third type. It's not a type, so to speak, right?
Okay.
Yeah. Okay. Right. Sorry to cut in.
No, that's okay. There is the summary offenses and indictable offenses. And the essence of classifying these offenses is because they have different penalties and procedure as well, and also the issue of jurisdiction. So it's important to differentiate these types of offenses. And there is another aspect that's called hybrid offenses, which is where the prosecution, the Crown, has to decide if it wants to prosecute the offense, whether as a summary offense or as a hybrid offense, and that will include considering certain factors like the grievousness of the crime, whether the accused is a first-time offender or if he's remorseful and things like that. But because of these hybrid offenses, it has been difficult to actually delineate between the different types of offenses now.
Yeah.
I think that's just about it.
I think that capped it. Good job, Amaka. So what I'm just going to add to that is you have to really pay attention to section 553 and the section 469, because it is outside these two categories that you now begin to delve into the realm of the hybrid offense, right? Where the prosecutor would now have to choose whether they want to go summarily or by indictment, right? So I think that is it. Okay, good job, guys. So Chapter 4, interpreting criminal provisions. How do you interpret criminal law provisions? Interpreting criminal law provisions is very important and essential to how you perceive and understand the offense that the accused person has been charged with. As a matter of fact, your skill at interpreting an offense will go a very long way in helping you defend or prosecute, the accused person, whichever is applicable. So what are the forms of, interpreting, or what are the various means of interpreting? So you have here, your criminal code is divided into parts, right? And very conspicuous is your section 2 of the criminal code. Your section 2 of the criminal code contains definition sections you find in all around the criminal code. So that is your very first source of, interpreting the criminal code, right? And then you have some words also interpreted at the beginning of each part of the criminal code. So those words is actually now limited to the words found in those parts. So you have your section 2, which cuts across every part of the criminal code, and then you have the words you find at the beginning of each part, which now is limited or restricted to the content of that part. Then sometimes you find the words in and around the section that you are reviewing as well. So these are 3 ways you can find words, and you can find meaning to the words that you feel it is vague or ambiguous, right? So those are just for me to throw that to you. But in interpreting criminal law provisions, you have different means of interpretation. You have what they call district construction, for example. District construction is a situation where the section or the word is interpreted in such a way that when you find an ambiguity in the interpretation, then the accused person will take benefit of the ambiguity. Remember, when we talked about the chapter 1, the sources of your criminal law, it must be clear, it must be written, it must not be vague. You cannot charge an accused person with a section of an offense or a section that is unclear, So the moment you have any uncertainty or you begin to have doubts as to what exactly is Parliament trying to prohibit here, are you with me? The accused person under strict construction begins to take benefits of that ambiguity, meaning that he or she would not be convicted on that section because the wordings of the law is unclear, right? So that is strict construction. But subsequently, we began to have conversations around should the strict construction be or not. Then it takes us to the next type of interpretation called the purposive interpretation. With the purposive interpretation is almost as good as the strict construction, but with an additional clause. What this one is saying, what purposive interpretation is telling us is, when you interpret the criminal law provision and you find an ambiguity in it, the accused person will not readily take benefit of that ambiguity. Are you following me? The accused person will not readily take benefit of the ambiguity. What would happen? Parliament is saying, review the section, having in mind the intention of the Parliament. What exactly is the Parliament trying to prohibit? What exactly is the purpose? What was the motive, for the particular law that had been enacted? When you consider the intention of the Parliament, or you consider the purpose of that legislation, or you consider the damage that the law is trying to, trying to prevent, you consider all of these factors before, saying the accused person will take the benefit of that interpretation. What purposive interpretation is saying as well is, when you consider the intention of the Parliament in interpreting that section, and then you still find some ambiguity in it, it's still not clear. Okay, yes, I've tried to see the reason why Parliament enacted this provision. I've looked at the rationale behind it. I've looked at the issue is trying to cure or the damage is trying to prevent. I still don't, there's still some uncertainty, there's still ambiguity. Then at that point, the accused person takes benefit of the ambiguity. Only at that point. Does this make sense? So your strict construction is saying, interpret the provision of the law, right? But the moment you interpret it and you find ambiguity, the accused person takes the benefit of the ambiguity. But purposive interpretation is saying, be purposive in your approach, as the word implies. It's purposive, like find out what is the intention of the Parliament. Find out what exactly is Parliament trying to achieve. Interpret that provision, having in mind, or having at the back of your mind the intention of the Parliament. Interpret it in such a way that you are able to amplify the intention of the Parliament. When you've done all of this and you still find ambiguity, okay then, the accused cannot take the benefit of the ambiguity. Does this make sense to you? The case you have in your syllabus is the case of Aram Pare. Aram Pare is the case of the guy who committed, what's it called? He had murdered the victim 2 minutes after he committed an assault. When you go into your study materials, you find that an assault becomes an aggravated assault when the application of force is grievous, right? So you be familiar with section 265 of your criminal code that generally defines an assault. And then it will also expose you to the different types of assault you have, right? And then you have aggravated assault, assault causing bodily harm, quite a host of them. I don't want to delve into that now. But in the case of Aram Pare, a murder becomes first-degree murder when the murder occurred while you're committing an assault. Does this make sense? Yeah. You see that it's first degree. So in this case, the accused person had murdered the victims 2 minutes after the assault. So, and the issue is, should this be considered first degree murder, considering that the murder didn't occur until 2 minutes after the assault? If you apply the strict construction, you will be saying that because it is 2 minutes after the assault, the murder did not occur while the accused was committing the assault. That would be your strict construction, right?
Yeah.
But if you apply the purposive interpretation, ask yourself, what is the parliament trying to achieve with this law? The whole essence of that law is to prevent people from committing assaults in such a way that it leads to murder. Before an assault can lead to murder, it must have been a very grievous assault, right? So the whole essence is to punish you more for committing an assault that leads to murder. So in applying that purposive interpretation, you will find that you'll be interpreting it that that assault or that murder was committed while the assault was taking place. Do you understand that case? Does it make sense to you? I love the case. It's pure fairness. Like you don't commit assault to the extent that the person dies from it, and then you go to court arguing that that assault did not lead to death. I mean, you can't do that. So the accused person was charged with first-degree murder, right?
But the person didn't actually die.
Sorry?
So the person didn't die? He just committed the assault on the victim?
The person died. The person died. The victim died. So the accused committed an assault, but the victim was alive when he was done with the assault. But then 2 minutes after, the victim died. And the issue was whether he should be charged for first-degree murder. Considering strict interpretation, you would say no, because the murder didn't occur simultaneously with the assault. Does this make sense to you? Yes. But then if you apply that purposive interpretation, where Parliament is saying, look into the intention. What is the intention of the Parliament here? The whole intention, the rationale behind that law is to prohibit someone from committing assault that leads to murder. I mean, committing assault on its own is an offense. Then committing it to the point that it leads to murder, it's a grievous offense.
Okay.
And then when you come to study your materials, you will find that there are different types of murder. There is the first-degree murder, there is the second-degree murder. So the first-degree murder is the one that you would have to show that the accused planned and deliberated on it. It is planned and deliberate, right? And it carries more terms of imprisonment. For instance, you can be charged or sentenced to 25 years, 15 years or more, and you will not have a right to probation until 10 years after jail. So it's actually grievous. I think it is the highest punishment you can have, right? So the issue in that case was, should the accused be charged for this first-degree murder? And of course, the courts, in applying that purposive interpretation, held that he should be charged for the first-degree murder.
Okay.
Right?
Thank you. Yeah. And
then you have your another way to interpret the criminal code is the different versions that we have, because Canada is bilingual. You have the French and the English version of all laws. So when you find that you have some ambiguity in interpreting the law, what the courts have been doing is to refer to the other version to help in clarifying whatever ambiguity they have. For example, you find the case of, is it Aramark here? Aramark in your syllabus is the case of where the court had to interpret the meaning of the word adapted. You know, the court, in interpreting the meaning of the word adapted, resorted to, the ambiguity that arose in the English version of the criminal code was clarified by consulting the French version. So sometimes the courts would always use that as a good way of interpreting criminal law provision. Another case you have in your syllabus is Aaron Collins. Aaron Collins is the case where the court was needed to decide the meaning of the word, shall and would in section 24 sub 2 of your charter. Section 24 sub 2 is the provision that talks about exclusion of evidence, where the courts, had come to the conclusion or this decision that the accused's right was breached in the process of investigation of a particular offense. What the court had said is that there is the option where the court would exclude inadmissible evidence in reviewing the case. So in this particular case of Aaron Collins, you find that the English version used the word shall, and I'm going to read that section just so this makes sense to you. Section 24 sub 2 says that the evidence shall be excluded if it is established that admitting it could bring the administration of justice into disrepute. That is the English version. Then you have the French version that used the word would. that says that Section 24 sub 2, the evidence would be excluded. The use of the shall and the use of would in this situation, the court needed to make a decision which one the court should use, because using the word would does not connote compulsion. It sort of made it look like the court has the option, but with the use of shall, it's compulsive, it's, very assertive, that the moment you find that a particular, evidence should not be admissible, then you shall exclude it. So this use of the French and the English, version of the criminal code can be very helpful in interpreting criminal law provisions. Does this also make sense to you? Then lastly, you have the charter. We've already talked about the charter and its usefulness earlier, but really here, charter can also be used to interpret criminal law provisions, like we already said. And again, you have the case of children, youth, and law against Canada here that I don't want to go into for the purpose of this introductory class. So in interpreting criminal law provisions, what I always say again is, it is helpful during the exam when you need to interpret a particular provision. So NCAs by practice bring you fact-based questions, right? Where you are supposed to identify issues and apply the relevant rules, right? So in a situation where you have this occurring, will probably be in the situation of the case of Aaron Parry, for example. You may find that in your exam in that fashion, where you needed to apply the purposive or district interpretation in interpreting the law that you've been given. Does this make sense? So for the NCAs, you may not have a lot to bother yourself on with this chapter, because it's just explanatory. Is to give you good understanding of how to interpret the criminal law, offense that you may be given in the exam. So with that, I think that is summary of my chapter 4. I'll hear from Benazir now to tell me what you understand with this chapter, the topic that we just talked about.
Right, okay. So in respect of interpretation, so first you talked about how the criminal code is set out in terms of its definitions, which are the broader definitions, and then the part has its own definitions which should apply to that particular part and all of that. And then we talked about strict construction, where there is strict construction is where it's interpreted in such a way that if there's an ambiguity, it's ruled in favor of the accuser's liberty, as opposed to the purposive interpretation, which is similar to the strict in construction, but there is an additional feature there where the accused will not take the benefit of the ambiguity, and you will look at the intention of the parliament, what they intended, and all of that. And if you find the ambiguity, then the accused cannot take the benefit of that.
Yeah. I was going to add that moment you consider the intention of the parliament and you still find an ambiguity, then at that time, the accused can take the benefit of the ambiguity.
Yes.
Right?
Yes.
Okay. I'm not sure I heard you say that. I just wanted to be clear that you got that. Okay, Amaka, do you want to speak to the French and English version and the charter?
Yes, let me add to that. For the French and English, because Canada is a bilingual country, where there is an ambiguity in, say, the French law, criminal law, you can resort to the English criminal law to resolve the ambiguity.
Good.
You gave a good example with Ara and Collins. Where there was an ambiguity between the use of the word shall and would. While shall is a compulsory word, would is discretionary. So using the French and English versions help to resolve the ambiguity. Then the charter also helps in interpreting criminal offenses because, essentially because it serves as a watchdog.
Exactly.
So it helps to know when you are breaching the human rights of the accused person.
Yeah, essentially. So that you have your ways of interpreting the criminal law provisions. All of these topics are just, at least the first 4 topics of the NCA syllabus is to give you a good understanding of the later part of the syllabus, right? So you may not really find questions in your exams that directly speaks to this thing, but if you have a good understanding of it, you are able to review your sections more in a very effective and timely manner, okay? So I will go to the meat of the syllabus. This is where my students always just say, you know what, ID, can we just go to the major one? I say, well, you need to understand this first part first before we go into the major one. You know, you can't put something on nothing, as they say. So the next part of your syllabus is the element of a criminal or regulatory offense. When we talk about the elements of criminal or regulatory offense, what exactly are we talking about? Remember your presumption of innocence. Remember that under your charter, your section 7, you cannot take away the rights and liberties of an accused person unless and until you comply with the fundamental, justice. So whatever it is you do with the accused person, you must be charter compliant. And it is on this basis that you have the need to prove the element of a criminal law offense. And you are proving because there is a presumption of innocence where the law presumes that every person charged is innocent, and the burden is now on the crown to show that you are what? Guilty, right? So in doing this, what exactly are we talking about? What are the elements of a criminal law offense? What are the elements of a regulatory law offense? We will take the elements of the criminal law offense first. We know, I'm certain we all must have heard of these, that there is the actus reus and there is the mens rea. The actus reus is the prohibited act, and the mens rea is the mental element of the offense, right? So before an accused person can be found guilty, prosecutor has the obligation to prove beyond reasonable doubt that the actus reus and the mental mens rea of the offense is present. And in doing so, he or she must also show that these two elements are present at the same time, right? Your actus reus, again, is the prohibited act. Your mens rea is the mental element of the crime. Both elements must occur simultaneously before an accused can be said to be guilty. Does this make sense to you? So now let's zoom in on actus reus. So we take actus reus first, and then we go to mens rea. So now, what is actus reus again? What exactly are we talking about in actus reus? So actus reus also, there are some elements that must also be present. Not just, you don't just take actus reus on the face value to say it is the prohibited act. Yes, the prohibited act. But before you can say that the actus reus is present, you must show that the act itself is unlawful, which takes you back to your source of criminal law, Amaka and Benazi. I know Temitayo joined us whilst we're on the call, right? Temitayo, welcome to the call, right? So it takes you back to chapter, what is that? Chapter 1, that talks about sources of criminal law. You know, it says to you that the Canadian Criminal Code is the major source of the Canadian criminal law. Of course, you have other enactments. So what this means is that before you can charge me for an offense, it must be that that offense has been stated to be unlawful in a particular legislation. So your actus reus cannot be present unless you prove that that act I did was unlawful. That's one. Remember the case of, I mentioned the case of Aaron Federock. Did I mention that case when we treated chapter 1, where the society just felt the act of the accused was immoral and it should, as a result, be an offense? The court said no. No matter how repulsive you feel about a particular conduct, it does not become an offense simply because you feel that way. The only thing that makes it an offense is because it is contained in a particular legislation. I know I think I explained it, but I didn't give the case. Yeah, I like that you are following, Amaka. So now, for actus reus element, the act must be unlawful, that is one, and the act must be voluntary or willed. The second element is that the act must be what? Voluntary and willed. What does this mean? It means that whatever it is the accused person had done should be done or should have been done voluntarily. And a very good example that the Ncaa has given you in your syllabus is a situation where a man is suffering from seizure. You know, you have a situation where somebody is suffering from seizure in a way that you cannot control your hands or you cannot control the part of your body, and then your hand just keeps moving that way. And let's assume Amaka was just by my side and my hand just went and then I slapped Amaka. And then Amaka reported me to the police and the police charged me with assault. What that means is that my act would not be an act of serious, because why? It was not done voluntarily. It's simply because I cannot control my hands, right? So the criminal code, the criminal law jurisprudence recognize that this particular point I'm explaining to you now would also be considered in mens rea, mental element, right? Yeah, it could be, but it is here under act of serious because the jurisprudence see that it is wrong to punish somebody for an act, to say, because an act of serious is an element of an offense, right? Let's assume we're in court now. The Crown was able to prove act of serious, but was unable to prove mens rea. It will go on record that the accused person committed the act, but did not have the intention to commit it. It is still on record, although you cannot be found guilty because, of course, there is no mens rea. But it is still on record that you did that act. Why this is important here is that it is said to be unfair to attribute a particular conduct to me, a conduct that I could not control. It is still unfair to consider it my act, regardless of the fact that it still would not lead to a conviction. Does this make sense? So it's just to say that at the end of the day, you should not say I committed an act when, of course, I did not voluntarily commit that act. It is too important that way. So you'll see that the issue of voluntariness will come in here, because unless and until my act is voluntary, and don't mix this with intention, they are two different things. Unless and until my act is voluntary, you cannot say it is my act. You cannot say I've committed a prohibited act, because that act was not voluntary. It is different from intention. I'm stressing this because I know sometimes my students just mix it up and say, ID, I don't understand why you're talking about intention when you're talking about voluntariness here as well. Voluntariness as to act is limited to the act, the physical act, particular exercise that was done. Intention is the mind. It is the intention that goes to the mind, the mental element. So there are two different things, right? So I'll go back to my list. I've said one, before an act can be called to be a prohibited act, it must have resulted from an unlawful act. So there must be an unlawful act, which is one. It must have been done voluntarily, which is two, and it must have been done without the consent of the victim, which is three. And sometimes you now have causation as also an element. Sometimes when you read through your Canadian Criminal Code, you find that some sections have been drafted in such a way that the Parliament expects that a consequence will occur as a result of that conduct. I'm going to take this part again because it's very important. Sometimes when you review your criminal code, you find that the Parliament has said that a particular consequence must occur as a result of your action before that act can be complete. It is not in all instances you have that situation. Some offenses do not require consequences. I'm stressing it because my student had asked me, ID, I believe every criminal law offense is consequential. I say, yeah, that makes sense. But in this particular case, the Parliament is saying a particular consequence must occur before that act can be complete. Right? So you would only need to add causation as an element of act of serious only if the Parliament says that causation is an element. Only if the Parliament says that a particular consequence must occur from your conduct, then you talk about causation. Otherwise, you do not talk about causation. So it is not in all instances causation. Amaka, do you want to unmute and tell me what you are thinking right now? Because your mouth just keeps flipping back and forth.
Please don't mind me. I was looking at possession and causation.
No, is this one here right now is causation.
Okay.
We are not there with, we've not arrived the possession part here yet.
Okay. Yeah.
So actus reus, basically 3 elements. Sometimes it can be 4. I'm trying to be as clear as possible. So the 3-1 you have constant is the act must be unlawful, it must be voluntary, and then the victim must not have consented. Of course, if you consent to a crime, how do you go to cry foul again, right? So the victim must not have consented. Then sometimes you have an offense that requires a particular consequence to occur. In that situation, that offense is not complete unless the prosecutor can prove that particular consequence actually happened. Otherwise, the offense is not complete. And then when you have it that way, then you must then prove causation. Causation is additional elements of actus reus where Parliament says so. Does this make sense to you? So, and then you then need to now delve in or zoom in into that conversation around the different types of causation you have. You have your factual causation, you have your legal causation. We can zoom in on that, but that's going to take a whole lot of our time. But it goes to show that under the Canadian jurisprudence as well, causation is divided as to factual and legal. It is factual if you say that a particular act of the accused caused the consequence to happen in fact. It is legal if you say that the act or the consequence arose was actually prohibited by law, right? If the accused can be found guilty in law, or if the accused can be found guilty in fact, is another way to say, right? So you need to zoom in on that and talk about factual and legal causation, and you have to review some of your cases like R&BT, R&Mabin, R&Navy, very interesting cases. I wish we could just review all of those cases, but my God, we're not going to have time to touch on the things I feel you should know in your introductory class, right? And then this takes me to the act of possession that Ncaa talked about earlier. You know, possession is singled out here because you have, it is a very unique situation where you have your actus reus and your mens rea not properly delineated. Does this make sense? The act of possession is an offense where it is difficult to separate actus reus from mens rea. So you'll find in your reading that you've been told that sometimes you may not have your actus reus or mens rea separated clearly for you. But the skill you need to have is to be able to identify it in the course of reviewing of your case. So sometimes you have the acts clearly spelled out. Sometimes you have the mens rea clearly spelled out. Sometimes you don't. And an example where you have it so fluid is in your act of possession. And you find that we'll look at it because for this one, we really need to look at the cases for it to make sense. The act of possession, before you can be held guilty for being in possession of anything, you know, being in possession of unlawful, you know, unwanted, what am I saying? Being in possession of stolen property, for example. Yeah, that was what I was going to say. Being in possession of a stolen property, how are you able to separate the actus reus and mens rea? Before an act of possession can be said to have occurred, you must have knowledge that the property you are in possession of is a stolen property. So 1, there must be knowledge. 2, there must be consent, that you consented to be in possession of that stolen property. And then 3, you must have control. You must be able to control it, either the ability to move it somewhere else or whatever. You should be able to control it. So these 3 things must be present before you can be found guilty to be, you know, in breach or violation of, you know, an act of possession. Does this make sense? And then of course you have different types of possession. You have the manual possession, you have the physical possession, and then you have the, which one? Constructive possession. You know, so physical possession, like you actually have the thing in your presence, but constructive in the sense that it is somewhere where you control. For example, you could have it in a system or in a cloud, you know, based version or whatever. But the whole essence of it is that no matter the form of possession you have, whether physical or constructive, you should have knowledge that whatever you're in possession of is stolen. 2, you have it because you consented to having it, and then 3, you can control it. So the The reason why it is here conspicuously in your syllabus is because the NCA need you to know that sometimes your actus reus and mens rea can be fluid. They can be interwoven. You may not be able to separate them. And the instance where that is so very clear and apparent is when you're dealing with possession, the law of possession, right? One of the cases they gave to you is Aaron York. You know, Aaron York was charged for being in possession of a stolen property, right? And what happened was I think the fact of Aaron York was the case of a guy who got to his parkade and found stolen property there. And of course, he panicked, like, where did this come from? These are not mine. He was going to move it and take it somewhere else. In the process of moving it, he was apprehended, and then he was charged for being in possession of stolen property. The court applied those 3 factors I mentioned earlier: knowledge, consent, and control. Did he know it was stolen property? Yeah. Did he consent to be in possession of that stolen property? You know the response. The answer was no, right? Could he control it? No, as well. These 3 knowledge, consent, and control must be present simultaneously at the same time, before the court can convict you for being stolen property. It was applied in Aaron York, and the court just said, you know what, this guy cannot be found guilty of being in possession of stolen property, right? The other example you have is in the case of Aaron Terrence. Aaron Terrence is the case of the guy found in a stolen car, right? You know, the guy was just in a stolen car, and he was charged to say that he was in possession of a stolen car. The court simply said no. He was in a stolen car, but was he aware that the car was stolen? No. So no knowledge there. Of course, no consent, and definitely no control. So the guy could not be convicted. Does this make sense to you? Interesting cases when you read them, you know, in depth. Aaron Morelli also is the case where, this case is important because it's the one that highlighted the difference between the physical and constructive possession, even though in this case it didn't go much, it didn't go down much. But what you should know that the guy was charged with being in possession of child pornography, and what had happened was that the police found that he's been visiting some, you know, pornographic sites. But what they couldn't prove is that he could actually control this site. So it would have been different if he downloaded the pornographic, you know, image or videos and he had it stored maybe on his X drive in his computer. But this guy didn't do that. Occasionally, he would just go on the web and then access the pornographic substance. The court held that he wasn't in control of that, so he couldn't be charged with being in possession of child pornography. Does this make sense to you? Right? So consent is also a very important element that you have to zoom in when you talk about actus reus. And essentially what you want to see is the victim consent to the crime that had been committed, right? In this instance, you want to look into the mind of the victim, right? How was the crime committed? How did the victim perceive the crime? Did the victim actually consent to giving the crime? And here you're looking at the subjective intention of the victim. So you need to look also, be familiar with the case of R against Ewanshuk. Although this case has been taken off the syllabus, I actually don't know why. I think it is still a very important case for you to know, because it is in that case that the court held that there cannot be an implied consent in Canadian criminal law. So there cannot be implied consent to commission of an offense. The consent must be clear, must be, you know, concise. And in this case, the victim consented. The victim and the accused in this case were in a car, I think, and the victim, with fear or something, consented to some act of sexual, you know, assault, but did not consent to some part of it. And the argument was that there was an implied consent, and the court said no, you cannot say there is an implied consent. So consent must be clear, must not be vague, right? So that case is important, at least to put in that point. Then you have the case of Ncaa. I really do not want to go into all of these cases, but if you look into the case of Ncaa, the defendant actually choked the complainant till she became unconscious, right? And while she was unconscious, the defendant performed some sexual, you know, act on her, and based on their previous relationship, the defendant's arguments was that she consented to the act because they've been doing it in the past. The court said no, that in this case, this consent was not there. So the accused person was actually convicted. A very important case also is the case of Aramabio. Aramabio is the case of the guy who had HIV and was having, sexual interactions with his numerous girlfriends without revealing to them that he had, HIV. And of course, you know what the decision of the court was in that case, right? So when you zoom into your section 265 sub 3, I'm not sure now, is the one that really talked about consent, and it actually gave us factors that will vitiate consent. So one of the factors is fraud, is abuse of authority, somebody in abuse of authority, and which is the third one? Threat, right? So if you threaten me to, and as a result of that threat, I allowed you to commit a particular act, which of course is an offense, you cannot go to court to say I consented. In that situation, the court is saying that threat has vitiated the consent. And the same thing applicable to exercise of authority and fraud. Anybody who stands in the position of exercise of authority, like a teacher, like who else? Your employer, anybody who assumes or that role of being in authority of anything you do, based on that situation of that position they have, if they do anything on you, and then you go to say, and then you go to court to say she consented, the court is going to zoom in on the relationship to see the authority here is not on the same scale. Like, so in this case, that exercise of authority will be used to vitiate the presumed consent, right? And the same thing is applicable to fraud. It was the fraud element that actually vitiated it in the case of Aramabio, which is the guy that refused to inform the girlfriends that he had HIV. That's basically fraudulent. You had HIV, you didn't tell me, and then we engage in several sexual, intercourse, and then you go to court to say I consented. The court will say no, that was pure fraud, right? And then the last thing you have under actus reus in your syllabus is we've been talking about an act, something that you've done, an act. Sometimes your actus reus can be an omission in the sense that you failed to carry out a particular act. And the moment you're talking about an omission, you are essentially speaking to the accused person must be in the, must have the authority to do a particular act. So you must also now show that the accused has an obligation, to do that act. And then failing to do that act will now constitute an omission, would now then be an offense. Does this make sense? So you must always show that the person who is omitting to do something has the legal obligation to do that thing, right? With this, you'll be reviewing cases on negligence a lot, and we can't zoom in on that here, unfortunately, right? So, but there are two cases in your syllabus. I should quickly speak to those cases. You have Aaron Peterson. Aaron Peterson is the guy, a very irresponsible son, I can say, that refused to take care of his old father. So the man lived in dirty environment, didn't give the guy food, and the guy died. And he was charged for failure to provide necessaries of life to his father. And the court held, yes, you have an obligation to take care of your aged father, and he was convicted. Another case is the case of Aaron Brown. Aaron Brown is the case of a friend that failed to take his friend to the hospital, and then he was charged for the same offense, and the court said, yes, as much as we recognize that there is a moral obligation, there is no legal obligation in this instance, and the guy couldn't be convicted, right? So I know I've said a lot under actus reus, and there's still a lot to be said, I have to admit, because you still need to review some of these cases in depth. But for the purpose of your introductory class, to give you an idea of what you should look at when you're studying, I think what I've said so far suffices, unless you guys disagree with me. But I want to know if you understood what I've said so far. So I know, I know we speak to about 3 or 4 things that we must always look at when we speak to actus reus. So Benazi, do you want to speak to those 4 things, and then we wrap up to go to the next topic?
Right. Yes. So sorry. In the act of possession, is that
reus generally?
Generally. Okay.
Yeah.
Yeah, sorry, I will just refresh. Yeah, so with the act of race itself has certain elements to it, such as it must be unlawful and voluntary, and the victim must not have consented.
Yeah.
And the fourth one was sometimes the parliament, within the criminal code, the parliament will specifically ask you for causation. So just in respect of those, then you have to consider causation. Otherwise, causation is not relevant.
Yeah.
Unless
Very
specified
good.
in the criminal code. Yeah.
Yeah. Very good. Very good. Okay. Amaka, do you want to speak to the rest? Speak to causation, speak to act of possession, and speak to omission.
Yes, there's also the issue of possession where mens rea and actus reus may be difficult to differentiate.
Yeah.
So that's when you, for instance, you talked about the offense of possession of stolen property, where the court will have to consider if there was knowledge that the property is stolen, if you consented to keep the stolen property, and if you have the ability to control the property. But aside that one, there is omission, where it's not necessarily an action. You're not required to act, but your inability to act actually arises to an offense itself.
Yeah.
So
that's correct.
That's because you have a legal obligation to act, but you failed to act.
Yeah.
So it's an actus reus.
Oh, very good. Very good. So the next topic we would have to deal with is mens rea, of course. But mens rea is a very, it's wide. It's not, I don't think we'll be able to cover it within the time frame that we have right now. I know you guys are enjoying the class. I'm also enjoying it, but we just have time to stick to. So your mens rea, like is the mental element required for the commission of any offense. So you must have the intention to carry out that offense, otherwise cannot be convicted or found guilty of that offense. But what we should also know is that the mind is not easily discernible, in the sense that, in fact, not discernible. Nobody can actually tell the mind of another person. But how do you come to the conclusion that somebody intended to commit the acts? You come to that conclusion by looking at the principles that say that a man naturally intends the natural consequences of his acts. So there's that presumption that looking at the circumstances of the offense, looking at the consequences of the offense, then of course you will be presumed to be in the intention or having the intention to commit that offense. So with this gives you the background to now delving into the topic, because knowing that I can only tell your intention from reviewing the natural consequences of that offense gives you a good background to understanding the topic of mens rea, because on its own, without this background, it becomes like, oh, how do I tell somebody's intention, right? So now, what are the different types of mens rea we have? In Canada, we have actually two types of intention. You have subjective mens rea, and then you have the objective mens rea. And then under your subjective mens rea, you still need to zoom in and look at different aspects of subjective mens rea. But for the purpose of this our introductory class, I'm going to say that subjective mens rea looks into the mind of the accused himself to decide or determine if he actually intended to commit that offense. So you are zooming into the mind of the accused and the mind of the accused only. That is subjective mens rea. Just as the word implies, it's subjective, is looking into the mind of the accused person himself. Whilst the objective mens rea is going into the field of the reasonable man's test. So here he's looking at the reasonable man's standard. So he's not looking into the mind of the accused person, but he's asking the question, would a reasonable person in the circumstance of the accused person or similarly situated with the accused person commit this offense? So that is objective mens rea. That is, the other one is subjective mens rea. The subjective mens rea has been considered to be the highest level of intention you can have, because it's more protective of the interest of the accused person, so to speak, right? And you have it applicable in your previous offenses like murder, treason, and the likes that you have under your section 469, of the criminal code. So now, understanding the type of mens rea that is required in the review of your offense section is very important in passing your NCAs. It takes a bit of exercise, but we always get to the point where you are able to pick a criminal code and you're able to tell a particular mens rea that is required when you review that section. That is the skill that the NCA actually want to test. That is the skill they expect you to know or to be aware of. You must have the ability to pick up any section that you've been given in the in your exams, review it in such a way that you're able to tell the examiner the particular type of mens rea that is required. Now, it is possible that you review this offense before your exam. It is also possible that you may not have seen that offense before. But your ability to quickly review it within the time given is what is required, which is what I seek to achieve with my students, basically. So now, how do you identify subjective mens rea in your criminal code, and how do you identify objective mens rea? Before we get there, let me explain the different types of subjective mens rea that we have. Now that you understand subjective mens rea is looking into the mind of the accused, how do you get there? How do you then get to say that, yes, the accused person actually intended to commit this offense? I always tell this story to my clients. As a prosecutor in my home country before, relocating to Nigeria, when I go to court, before relocating to Canada, I beg your pardon, when I go to court and I need to prove that the accused person has the intention to commit an offense, the law as it is drafted in my home country is not drafted in such a way that it helps me to identify these things. So I will go to court using every sense I have to prove to the court that the accused actually intended to commit the offense. It was difficult. Then it wasn't so difficult to me, but coming to Canada now and seeing the way the laws have been drafted, seeing the jurisprudence and the textbook and the materials, I in her, like I so appreciate that they are so thoughtful to put it in the way they've put it in such a way that it helps the Crown as well as the defense lawyer to go to court and then channel their argument properly in a better or effective manner. Because what I'm about to explain to you is what I did not have in my home country, right? So all I had was that you have the intention, like there must be an intention for every criminal law offense before the accused can be convicted. What I didn't have is that there are different ways that can help you to identify this intention, which is what you have in your syllabus now. So if you flip through, you see that under subjective mens rea, you have what they call intention, purpose, and willfulness. Intention, purpose, and willfulness is one of the ways you can easily discern the intention of the accused person. How? Because we are looking at what exactly did the accused person do? What was the act? What was the intention? And then you are pairing it vis-a-vis the provision of the law that the accused person has been charged with. If you look at the intention that the accused person had, it must correlate with the intention that the parliament actually stipulate, right? And again, it is the case law that is going to explain this very well for you. And I always use the case of Regina and Buzanga and Dorocha. Is one of the cases in your syllabus. In this case, what the accused person had done, the accused person was charged with intention of causing uproar, intention of causing, to ensure that there is chaos in the society, right? What this accused person actually did was to paste some pamphlets on the walls of is it in Quebec? This case happened in Quebec, I'm not sure right now, right? They pasted the pamphlet on the walls, and the whole essence of them pasting that pamphlet was to prompt the government to, establish a French school. That was the intention they had. They just wanted to jolt the parliament or the government to establish a French school. But then the accused person was charged under section 281 of the criminal code for intentionally promoting hatred. So if you look at their intention, and then if you look at the offense that was charged, they don't correlate, right? So I was charged for promoting hatred, whereas yes, that parliament was said to incite some whatever feelings in people around the area, but the intention of the accused person was not to promote any hatred. Their intention was basically to promote or to ensure that a French school was built. So now if you charge me under 26281, you must then prove that that purpose or the intention I had was to promote that hatred. The prosecutor failed in proving that, and of course the accused persons were not convicted. That's one way. So you must look at the intention of the accused person, and then it must be the intention that Parliament actually said they must have before you can say an offense has been committed, right? Another case is case of R and Ebert, but R and Ebert, when I review it, it takes me a bit of time to do because of the complexity of the case. But in brief, the accused person was charged for under Section 21, which you come to see is a section for aiding and abetting in the criminal code. He was charged for aiding and abetting an accused person to commit murder. What happened in that case? The accused person, in this case, the principal offender, went to the aider, that's the accused person that I'm reviewing right now, to lead him to the house of another friend of theirs. There's a situation where I need you to go to a friend's house to prompt him to come down so I can hurt or kill him. So the accused person led the principal offender to the place and held the victim for the accused person, leading to the death of the accused person of the victim. And then he was charged, of course, as aiding and abetting the crime, basically. So under that section, if you look at the way and manner Section 21 was drafted, Section 21 is been drafted in a way to show that whatever it is you do as an aider or an abetter, you come to understand those two terms because they mean different things. Maybe when you have the opportunity to attend my class, they mean two different things. As it is, the accused person was charged for, assisting the principal offender with killing the victim. And under Section 21 sub 2, the whole purpose of it is that you are aiding somebody for the purpose of aiding them. The purpose is to aid. The purpose is not that you intend for the crime to be committed. You are aiding the commission of that offense. It is limited to that. So in reviewing the case of R and Ebert, and the court has to decide if the court should leave the defense of duress to the jury. This case is very complex. The court had to decide if the court properly instructed the jury as to the defense that was applicable. These are technical terms that will unravel in class, actually. The court at that point held that the instruction to the jury was wrong because the way you instruct the jury, you must instruct the jury as to the situation of the law or the position of the law to help the jury in making a decision. The jury don't know the law. They are the trial of facts. They rely on the advice or the instruction that the judges give them. So you have to instruct the jury properly as to the situation of an offense before they are able to actually carry out the work, such that if the superior court finds that the judge was not properly instructed as to a particular situation, it's an opportunity for the court to always order a retrial or to rescind whatever conviction that had been heard, right? So in this situation, the jury was not properly instructed as to the purport of that Section 21. Section 21 does not emphasize that the accused should have the intention to carry out the offense. The only thing it said is that whatever it is you've done is for the purpose of aiding somebody. So you limit it to that. So any instruction to the jury that is contrary to this will mislead the jury, which was what happened in the case of R and Ebert. Again, I will leave that case once we have the opportunity to review it in full, but goes to show that whatever intention the Parliament intends for a particular offense must be the intention that is applicable or that will be applied in interpreting that provision, right? So Section 21, as it is, was wrongly, misinterpreted or explained to the jury in the case of R and Ebert, and the court had to say, okay, this qualifies for a situation where the accused person should be retried, and the case was sent back to the trial judge. Anyways, that's the intention and purpose and willfulness that I needed to highlight in that situation. The next type of mens rea you have that help you in understanding the intention of the accused person is what you call subjective mens rea with objective features. Subjective mens rea with objective features is limited and applicable to two types of offenses: sexual offenses and fraud, right? And what this is saying is that as much as we are looking into the mind of the accused person to determine that he actually intended to commit that offense, when it comes to these two types of offenses, which are fraud and sexual offenses, we will be applying some standards to it. We will be applying some objective standards in interpreting that intention. What does this mean? When you say somebody has been charged with sexual offense, two steps you must take. One, ask, did the person have the subjective intention, subjective mens rea to commit that sexual assault? That will be your first question. If your answer is yes, then you move to the next question. The next question will be that, would a reasonable person consider that touching a sexual act? Why is this important? Because if you go to court as an accused person to say, I touched the victim, or I touched Amaka in a private area, but I do not understand that to mean a sexual touch. It is for this reason that Parliament is applying an objective feature to the understanding of that act, such that the moment I show that you had a subjective mind to touch me in my private area, then whatever explanation that the accused person would have as to what he understood with the touching will become irrelevant. So there's an objective feature to the touching. Does that make sense? There's a standard to it. So once I say, I touched you in your private area, the Crown would have the obligation to show that I actually intended to touch you in that area. Once the answer is yes, then whatever explanation you have as an accused person to say, oh, well, I don't understand that to mean sexual touching. Oh, well, I touched her in a private area, but to me, that is not sexual touching. Court will say to keep quiet. Just basically tell you keep quiet, because the moment we say that you touched he or she in their private, then there is a standard we are applying to it is objective. It's objective in the sense that the society only understands that touching to be sexual touching. So subjective mens rea with objective features. In your exams, once you find a question on sexual offenses or sexual assault or fraud, you should know that this is the applicable mens rea you need to review to the examiner, right? Then the other type of mens rea you have, well, another way that you identify the intention of the accused is knowledge, you know. So here you just need to show that the accused person has knowledge of a particular situation, right? So for example, the accused has been charged with, you know, assaulting a police officer. What do you need to show? Before you can even show that before you can establish that I'm guilty for assaulting a police officer, you need to prove that I was aware that the person was a police officer. So knowledge is a good way to say that, to identify or to say that the accused has an intention to commit an offense. Once I can show that the accused person has the knowledge of a particular situation, then it is presumed that he has the intention to commit that offense. Does that make sense? Simple as that. You have willful blindness. Willful blindness is also another way to impute subjective mens rea. Willful blindness is a situation where you personally saw a risk. You see a risk, right? The accused person actually saw a risk, but was so, you know, conscious of confirming that risk just so that he can go to court to say he has no knowledge of it. So you have a situation where the fact is clear, the fact is apparent to you. All you needed to do was to take a further step in confirming that thing, but you refuse to confirm because you know that once you confirm, you will have knowledge of that thing. You want to be able to say to court that you do not know. So in that situation, you stopped yourself from confirming. In that case, I can go to court as a prosecutor to say you are willfully blind because you chose not to know. You simply just chose not to know. The facts are there, everything is there for you to see it, but you chose not to see it just so you can rely on the fact that you didn't see it. That's another way to impute subjective mens rea. The last one will be recklessness. Recklessness is a situation where you see a risk, right? And you already identified the risk, you are aware of the risk, but you chose to carry out the acts anyways. You are subjectively reckless. Recklessness is a subjective state of mind, right? So once I see that there was a risk, you saw the risk, and you still decided to carry out the act, then I can go to court to say you intended to carry out that act because you were reckless, right? So those are the different ways that you can impute subjective mens rea to an accused person. The next type of mens rea will be your objective mens rea, but I can see I've gone over my time right now, and unfortunately, I will not be able to go further in this. So Benazi and Amaka, I know I have Danny on the call, but Danny has chosen to keep quiet. So what do you understand with subjective mens rea? Just a summary.
Well, with subjective mens rea, there's certain it's looking at it from the standard of that person himself rather than of a reasonable person.
Yeah.
And so there are certain tests that would be applied, such as intention, purpose, and willingness. Is it?
Willfulness.
Willfulness. Yeah.
Yeah.
And and then again, knowledge is a good way of showing intention.
Yeah.
And then we spoke about a few of the cases. You know, we went into the details of those cases. I think I just have to read them in my own time to understand.
Yeah, you need to find time to read them. Yeah.
Yes.
So you have your willfulness, you have your knowledge, you have recklessness.
Recklessness as well.
Yeah.
You see a risk to still go ahead and, you know, do it despite the risk that you've identified.
Yeah. Yeah. So what I've not been able to tell you now in this introductory class is how to identify this mens rea in your criminal code, right? I wish I could take a minute to do that, because I think that's the whole essence of reviewing this topic with you. Because in Ncaa exams, you would have to identify the particular mens rea that is required, and you have to tell your examiner the particular mens rea that is required. How do you know that? When you go into your criminal code, there are certain words that will show you, tell you the particular mens rea that is required. For example, if you read a section and you see the word no in it, no as a word, N-O, no, and N-K-N-O-W, no. Anybody who commits an act knowing XYZ is an indication that that act or that section requires a subjective mens rea. And then in reviewing your provision, you will be telling the examiner that because of the presence of the word no, Parliament intends a subjective mens rea. Another word you will look out for is no, willfully. Willfully is another word. When you review a particular section and you see in the body of the section, you see anybody who done XYZ, willfully doing XYZ commits an offense, then you know that that section is also requiring a subjective mens rea. So, but the general rule is that in most criminal law, in the Canadian criminal law, subjective mens rea is intended. When subjective mens rea will not be intended, the Parliament will clarify or state clearly that objective mens rea is applicable. I'm sorry I'm not able to delve into this in depth, because it's actually impossible to do that within the 2 hours framework that we have. But suffice to say that in reviewing your sections, watch out for those words that point you to subjective mens rea. And then if you don't find them, there is also a phrase that helps you to identify objective mens rea. I should really stop talking right now, because I obviously can't go into those topics. I've run out of time, right? I apologize for that. I wish I could, really. So that ends the introductory class. My name is Hidayat. I'm Canadian criminal law tutor for the Ncaa Guides. You can reach me at hidayat@ncaaguides.com. I'll spell that for you. idayat@ncaaguides.com. If you choose to self-study, I wish you all the best. Pay attention to the pointers I've given you. If you choose to attend my class, I'll be glad to have you in my class. And that would wrap up today's session. Amaka, do you have anything to add?
Nothing, but I just wanted to just say that there's also this subjective measure that has objective features.
Yeah, that one. That one, watch out for that one. That one helps. That one is good because you know at least you're dealing with two types of offenses. So I always tell my students, once you go into that exam and you see a fact pattern centered on sexual assault or fraud, just go back there. That's so clear. Yeah?
I have a question.
Okay, Benazzi.
Yes. So the pattern of the exam are what kind of, like, for example, in admin or other, you would get one long question, and then there would be so many different things that form part of that question. What are the criminal law questions like?
The criminal law questions are fact-based as well, but recently what NCA would do is to give you a fact pattern that evolves all through the section. So you have a fact pattern starting with somebody committing an assault, and the fact pattern will be changed to accommodate a defense, that may be applicable. In the next question, the fact pattern may be changed to accommodate a question on sentencing. Basically, you have the same party running through different types of the questions. So basically, you have 6 questions with different fact patterns centered around the same, accused persons. So that's what you should expect. So you should expect question on offenses. You should expect question on defenses. NCAs, you cannot escape question on police powers. Police powers is the one that will give you or test your ability on your charter knowledge, the Canadian Charter of Rights and Freedoms. And then a very, another question that is regularly repeated is the question on sentencing. So you should look out for that. By and large, these are the kind of questions you get. But then some of my students informed me the last exam they got short questions that just zoomed in on some topics or some key things that you may ignore. So you should also pay attention to the fine details when you're studying, essentially, because they may just ask you a 5-mark question that randomly test your knowledge of the entire, syllabus, right? Did that answer your question?
Yes, very much so. And is this the same syllabus that comes in the bar exam as well, more or less?
Well, I'm not aware of the bar exams and the kind of syllabus that you need for that. But what you can send us inquiries. You can send an email to inquiries@ncaaguides.com if you have this question. We have, persons that can actually answer that questions. I'm not aware of the Canadian bar. Okay. But for the NCA, the most recent syllabus you have right now is the November 2020. So make sure when you go download your syllabus, it is the most recent you're downloading. The most recent I have right now, I've not checked the syllabus today, which is advisable that you check. Always check before your exams. The revised one is the November 2020. So that's the one you should use to study. Yeah.
Okay. Yeah, great. Thank you so much. That was really, really helpful.
You're welcome. I'm happy to help. So that ends the class. Amaka, thank you. Thank you all for joining. Feel free to email me if you have any questions regarding the intensive class. We're happy to answer it. Thank you.